Good evening, everyone. I hope I am audible. My name is Preet Samaya, and I am honored to be your host today. On the behalf of the Law Jurist, I would like to warmly welcome all of you to today's session. It's fantastic to see so many of you here, eager to gain knowledge and engage in what will surely be an enlightening discussion. Let me take a moment to introduce Law Jurist to those joining us for the first time. Law Jurist is pioneering platform dedicated to empowering the legal community, particularly law students and legal professionals, by providing the insights and resources and opportunities they need to excel in their careers. Law Jurist is a registered company, part of the Skill India initiative, and proudly holds an ISO certification, which speaks to our commitment to maintain high standards of quality and professionalism. Our mission is to bridge the gap between legal education and professional practice by offering a wide range of resources and learning opportunity. We are dedicated to helping law students gain valuable experience in various legal fields. Through our platform, students can enhance their legal skill and deepen their legal knowledge. We offer numerous opportunities, including internship, research projects, and student editor roles, to help students apply what they have learned in real world settings. Additionally, we are building a comprehensive database of case laws, developing law notes, blogs, articles, and legal updates to support students in their studies and also provide service to legal professionals. Whatever you are preparing for your legal career or looking forward to build a strong professional identity, Law Jurist is here to support your journey. Now, I have to I have the honor of introducing the driving force behind Law Jurist, Mr. Ayush Gaurav, our founder. Mr. Gaurav's vision and dedication have made Law Jurist leading platform that nurtures legal talent and innovation. Under his leadership, Law Jurist has become a beacon of knowledge and opportunity for the legal community. I would now like to invite Mr. Gaurav to share a few words with us.
Thank you, P, for such a warm welcome. Good evening, everyone. I am Ayush Gaurav. I'm the founder of Law Jurist, and I'm very excited to see such a wonderful turnout today. And although I suspect it might have been something related to our incredibly popular guest speaker, Mr. Anish Anand, guys, Law Jurist is not just a registered and ISO certified company, but also an initiative to bridge the gap between the legal education and student. We work hard to give students and professionals the resources they need to drive in legal world, and because of this, we have gained a lot of popularity in very less time. And today, I am especially grateful to our guest speaker, Mr. Anish Anand, for taking out time from his busy schedule and to join us and share his insightful thought about this particular topic. I'm sure this session will be very fruitful, and you guys will be having a lot of takeaway from this session. Thank you for joining, guys. Thank you.
Thank you, Mr. Gaurav, for your inspiring words. Next, I have the pleasure of introducing our distinguished guest speaker for today's session, Mr. Anish Anand. Mr. Anish, Mr. Anish Anand is a well-known legal scholar, a prominent MUN participant, and an aspiring judicial aspirant. His list of accomplishments includes being recognized as the best youth parliamentarian by the Jharkhand Legislative Assembly and receiving the Best Member Award in the Legal Literacy Club from the former Chief Justice of Jharkhand. He is also a winner of several months legal debates and quiz competitions. Today, Mr. Anand will be leading an engaging session on the topic Judicial Activism, a necessary evil or a threat to separation of power. He will explore the fine balance between judicial intervention and constitutional principles, diving deep into whether judicial activism is beneficial or detrimental to the separation of power in a democracy. Before I invite Mr. Anand to begin, I kindly ask everyone to maintain decorum during the session. There will be a two Q&A session. One will be taken between the session and one at the last. The Q&A window is open for your questions and you can start asking the doubt in the Q&A window. All of the doubts will be cleared by speaker accordingly. If time permits, we may also unmute participants for live questions. Without further ado, I would now like to invite Mr. Anish Anand to share his thought and insight with us. Mr. Anand, the floor is yours.
Thank you so much, Madam Preet, for such a well decorated introduction. But I must say that I'm just an imaginer in the world of Waldo, who said that there is no better way of imagination than the study of law. So, today, the topic which we are dealing with is judicial activism. To start upon, first we need to first clear our basic concepts. We all know that the social contract theory, which was proposed by various philosophers such as John, Rousseau, Locke, what it explains to us is that in the starting eras of civilization, when there was no governance, when there was no mode of controlling the rights and liabilities of the people, there came such structures or such institutions through which the early humans tried to form a society and tried to bestow their rights to a person or to an institution which can take care of their rights as well as which can give a security to them. Thus, there was different governance models such as kingship, monarchy, there was dictatorship, and various other forms of government. At the later stage, in the early centuries of in the early 16th centuries, we can see that there was the advent of democracy. Democracy, we all know, in the simplest meaning, is that the rule of people or the rule by people, and hence the basic concept in a democratic government is the division of power between different organs of the government. These are the basic legal, or I must say, the basic political concepts which we all are aware, and it has been taught to us in our school days. The three major organs of the government is the judiciary, legislature, and the executive. The legislature has been bestowed with the duty to make laws, to form legislations for the country. The executive, on the other hand, has the power to implement it, and judiciary, being the balancing actor in this field, plays an important role by interpreting that law as well as keeping an eye, doing working as a watchdog for the democratic society. Further, when the question of judicial activism arises, there is always a question that is it a threat to separation of power or not? Separation of power is also very interlinked with the formation of a government in a democratic society. Separation of power, as we all know, that in a simple term, it means that the three organs of the government should not overlap into each other domains. The executive should not act as the judicial watchguard. The legislature should not step into the field of the executive to perform public administrations, and the judiciary should restrict itself to the cause of interpreting the law, administering it. But there has been some instances we can see where there is a overreach of such powers of the different organs of government, and this question always comes to our mind that is there any harm? For example, if the parliament at some times tries to execute a law or tries to implement a law, what harm is therein? Or if the executive is given the power of judiciary to decide cases, then what will be the threat to the democratic model or to the democratic society? Hence, to understand this, I would take you back to the writings of Montesquieu. Montesquieu, in his book The Spirit of Law, mentioned that if there is no separation of power, there would be an end of liberty. That means if any two powers of the government has been bestowed to any one organ, the rights and liberties of the people would come to an end. Why? Because there are many cases which we see, which we read, are against the state, is against the government, that is the executive. If the executive is given the role or the function of deciding upon that cases, there would be a chance of biasness, there would be a chance of use of their dominant power in that field, which definitely will lead or which will harm the basic concept of a democratic society. Hence, for an advocate, for a lawyer, or for a legal student, it is very important that whenever we study upon any subject, whenever we study upon any topic, we should always thrive to respect, we should always try to preserve the rights and liberties which are guaranteed to a person by virtue of our constitution or any other legislation made by the competent party. Hence, when we talk about judicial activism, we can see that first we have to look upon what was the origin or from where this word judicial activism came, what is the whole definition or concept behind it. So we can see that judicial activism, in a very simple term, and many of you must be knowing, that it refers to a situation when the judiciary steps into the role of the legislator, such as the judiciary not even just reviews the law made by them, but sometimes also tries to further interpret them and add their interpretation into the laws made by the legislature, and brings up a different kinds of rules or laws in the nation, which is not the role of the judiciary. This judicial activism, as we all know, and the basic question here is that from where does was the origin of such concept came into our notion. As I remember, the then Chief Justice of the United States, Lord Heward, mentioned that it is of a fundamental importance that justice should not only be done, rather it should obviously and undoubtedly be seen to be done. So, from this concept, it comes out that through this idea of the then Chief Justice, many judges who were known as activists have given a judgment which showed the concept of judicial activism, rather, which showed that the legislator, when making laws, if there are flaws into it, then the judiciary should step into and add their interpretations for the welfare of the society. One meaning of the supreme in our Indian Supreme Court also in various judgment has given different meanings to the word judicial activism, and the most prominent one is that the meaning of judicial activism is that the function of the court is not merely to interpret the law, but to make it by imaginingly stranger with the passion of the constitution for social justice. So we can see that what are the main elements here: constitution and social justice. The courts, the judiciary has also been bestowed with this power to preserve the constitution for the purpose of social justice, and hence for this goal the judicial activism, if ever used as a tool by the judiciary, should not be questioned upon. So if we can see that in the early stages, so now we'll go to the history of judicial activism in our next slide. This history dates back the word, because we can see the word judicial activism was first, it is, and it is also a very interesting fact that it was not coined by any judge, it was not coined by any legal scholar, rather this word was coined by a normal author, or we can say a normal journalist by the name of Arthur Schlesinger Jr. Mr. Arthur, in his magazine Fortune in the year 1947, first coined this term judicial activism. So, in his particular article, what he did was, as we know that the total of that time there were total of 9 judges in the U.S. Supreme Court. The Mr. Arthur, he made a report about all the 9 judges, about their activities, about the way of writing their judgment and giving decisions. And hence he came with this word that during the during the New Deal era in the US, the Supreme Court not even just restrained many legislations of the Congress, but rather they also added their own interpretations to such legislations, and hence this term judicial activism was came to be known to the masses, and it was being used by the people thereupon. And we know that if we have studied the constitutional history of US, there was a famous case of Marbury versus Madison. Marbury versus Madison was the first case when judicial review was used by the US Supreme Court. In this particular case, what happened? Marbury was a judge who was appointed to as a Supreme Court judge. His letter was sanctioned to him, but his appointment, the warrant of his appointment, was not yet made, and hence at that time only Justice John Marshall was appointed as the Chief Justice of Supreme Court of the US. The then president retired, and because of the change in the executive institution, the appointment of the judge was withheld. So Mr. Marbury questioned this in the front of the Supreme Court of US that as per the Judiciary Act, yeah, am I audible now? If you can,
Yes, Anish, you're
Yeah, yeah,
audible.
you are
sorry
audible.
for the interruption. So what I was telling, that in this particular case, as Mr. Marbury, who was not yet appointed as a judge, he claimed that as my letter of appointment has been signed, my warrant should have been issued because the Judiciary Act has mandated this. But in this particular case, Supreme Court first ever used the power of judicial review, and it gave the ruling that as per the Constitution, the Supreme Court only has jurisdiction to hear the cases on appeal or to take cases on constitutional matter, not on any other particular legislation of the Congress. And if the legislation is inconsistent with the Constitution, then only the Supreme Court could review a matter. And hence, the court, Justice John Marshall, held that this particular Judiciary Act, which is in question, this is not just in violation or contravention of the Constitution, rather, it is also against the law of the land. And hence, this act of the Congress, which was voted by majority in the Congress, was first struck down in the US jurisdiction. So when judicial review was started being used in US, the Supreme Court further then brought the concept of judicial activism, and thus the first case of Brown versus Board of Education. It was a civil rights case, was the first judicial activism case which came up in 1954. After that, there was many other cases during the New Deal era. Post 9/11 terrorism cases were there, where the U.S. Supreme Court obviously use the concept of judicial activism to struck down laws or to add their own interpretation, so that to make legislation in favor of the Constitution of United Nations. So this is just a brief history how this concept came to be known through the common law parlance or through the United States jurisprudence. Now let us go to the evolution of judicial activism in India. As you know that there are two theories behind the concept of judicial activism. What are the two theories? The first theory is the theory of vacuum filling. What is this vacuum filling? So as we discussed that there are three more main institutions of, or the organs of a government, that is number one, executive, judiciary, and legislature. Whenever whenever any two organs of whenever any two organs of the government does not use their power in a proper way, or they they show some laziness, they show some inactivation in their governance system, there is a vacuum created in the power structure. For example, if for a year the parliament is not in session and no laws and legislations are drafted, this clearly shows that there has been inactiveness at the part of the Indian Parliament. Or if the executive, the government, is not at all in function for a very prolonged period of time and is not framing any policies for the nation, there is a vacuum created in the power structure. So, in such a situation, any other organ of the government has to step in and fill that vacuum which has been created. So, to avoid this, the judiciary sometimes steps into the shoes of the executive or the legislature to fill the power vacuum which has been created. This is one of the theory of the for the concept behind the judicial activism. The second theory is of social want. So social want is, as we know, that uh, there is always in our society a need for social changes, and those social changes sometimes are not accredited in the society because of the failure of the existing legislations to cope up with the existing situations and problems in the country. So when such failure is made on part of the legislature to form such legislations to answer the social problem or to answer the social situations in our country, the third organ or the watchdog of our democracy, judiciary, has to come into place, and hence judicial activism plays a very vital role in bringing the societal transformation. And further, we'll see through different cases and through different examples how the judiciary has played an important role in transforming the societal perspective in the Indian society. Further, in India, we can see that the concept of judicial activism, it first emerged during the emergency period. We all know that in 1957, national emergency was applied all over the nation, and hence this gave power to the court to defend the rights of the people, as because the two organs, the legislature was not at all in a role, the executive was overreaching its authorities or its power. Hence, there was a power vacuum created on part of the legislature. To fulfill that power vacuum, judiciary has to step in to defend the rights of the citizens. Then further, during the era of PIL, that we all know, public interest litigations, there were two most prominent judges or jurists in our nation, that are Mr. Justice P.N. Bhagwati and Justice Krishnan Iyer. These two particular judges are always regarded for the promotion of judicial activism and also for introduction of PIL into our judicial system. PIL, we all know, public interest litigation, is a form of or is a mechanism to file complaint to the high courts or to the Supreme Court in cases of a public wrong, or for example in environmental cases, in a social case such as a case of we can say similar to a large killing of people, or we can see a harassment of people. Such particular cases could be seen as such particular cases are taken up by the judiciary through the filing of PIL. And hence, when this, so the PIL kind of is a thing which, where the judiciary steps into the role of a public administrator. It, because when in the normal parlance, the work of a judiciary is that when there is a dispute between two parties, when the two parties are not on the same parlance, or if any right has been violated, then through a proper channel, a case is filed from a lower court to the appellate court and then to the Supreme Court, and hence the case is decided. But in the case of PIL, what the judiciary is doing, that they are not just taking up the cases for deciding upon the rights, but rather they are just taking a complaint from normal people, and also on a suo moto basis. This function should have been performed by the executive. The executive should have been looking into such policies or such legislations to be brought, so that such issues could have been resolved. But the judiciary taking such role is the case where the judiciary is undertaking the role of a public administrator and answering such questions of policy. Hence, we can see that this is also a very big example of judicial activism, as well as the initiation of the phase of judicial activism in India. You can see in the slides there's a mention of the Keshwananda Bharati case. For a legal student or any person related to the law field, this particular case is very crucial and very important, and we all are aware of the facts of the decision of this case. But you must be thinking that why it has been mentioned in a discussion for judicial activism. So, in the Keshwananda Bharati case, we all know that the basic structure doctrine was proposed. What is the basic structure doctrine? That there was a list of particulars given, that these things in the constitution, for example, the, the democratic feature, the social feature, and the fundamental rights, all these consist of the basic structure doctrine, and which cannot be altered with, and which cannot be changed by the parliament, and thus it was limiting the power of the parliament. Hence, in so the judiciary overstepped its work. The work of the judiciary is just to interpret the laws, but rather in this case the judiciary overstepped, and it purported a limitation on the powers of the parliament, and hence it is a very good example of judicial activism. Further, we can see that in India there are different particular various fields in which judicial activism has been used. One by one, you can see some of them have been mentioned here. And so, before further going into our discussion, if you are having any questions, you can definitely post them in the Q&A session, the Q&A platform, and you can put it at the end also. There is no issue, and if you have them right now, you can, if you want, it can be answered through the session, but at the end we are having a Q&A session which you can utilize them for asking your questions. So further going into our discussion, the that I was talking about, what are the different various fields in India where judicial activism have been used, or which various field where the court has overstepped its power of uh, doing interpretation of the particular um, constitution and legal fields. So first area is towards the beneficial effect, towards the benefit of the society. That is the second theory, if you remember, the theory of social want. Prior to the 1970s, the view that existed among the common mass was that the parliament was the common view among the mass, that the parliament is the sovereign body, and it can override not only the executive but the judiciary and also the constitution. So before the 1970, this was the concept prevailing in India, that parliament can even overstep anybody because it is a sovereign body. It has been elected by the people of the nation. It has been elected by the people of the nation, and hence to change this concept, there was various cases done in this nation, such as the Golaknath case, the Keshwanand Bharti case I just mentioned, the Menaka Gandhi case. In all these cases, the judiciary reaffirmed and affirmed that the parliament also has a legislation, and the constitution is the supreme and the sovereign body in the nation, not the parliament. Because the constitution, because the parliament is also an institution which has been created by the virtue of the constitution, and which derives its power from the constitution. And after the abolishment of the constituent assembly, constitution remains the single sovereign body in the nation. And hence, The powers of the parliament was also restricted, was also limited. There was there was there were many other cases where the Supreme Court, not only through the mechanism of judicial review, restricted the legislations of the government, but rather they also gave a new interpretations to some legislation, so that those legislations should reach the last person standing in the line, which can be described through the words of Mahatma Gandhi as Antodaya. So Supreme Court in a judgment also mentioned that as Mahatma Gandhi, who believed that the who believed that the benefit of any particular policy should reach the person who is last standing in the line. In the same understanding, the Supreme Court also has interpreted the various beneficial legislations. And one example coming to my mind is about the Maternity Benefit Act. So in the Maternity Benefit Act, there was no coverage given to the women laborers who were appointed on a daily wage basis. But in a radical judgment, that and if I'm not wrong, there is a judgment of Delhi High Court where they enumerated that the women who work on a daily wages basis and who are not sanctioned laborers would also get the benefit of the Maternity Benefit Act. Thus, this is a step of judicial activism, but for the benefit of the people, for the benefit of the society. The next sector we can see is the pro-environmental stance of judiciary. In the pro-environmental stance of the judiciary, we can see that the so pro-environmental stance of the judiciary. We can see if there are many cases we are aware of where the court has included the right to a healthy environment, the right to free air, the right to clean water under the domain of Article 21. A plain reading of Article 21 just explains us that a person has the right to has the right to life, liberty, and but the court, through various judgment, has interpreted and included various other rights. After the Bhopal gas tragedy, there has been cases such as MC Mehta versus Union of India. There is the Council Ratlam case, Municipal Council of Ratlam case. In all these cases, the Supreme Court, using the tool of judicial activism, has included the right to clean environment, the right to healthy air, clean water under the purview of Article 21. So this is also a domain where the Indian Supreme Court or the Indian judiciary has used judicial activism not just for the benefit of people, rather for the benefit of the environment and for the future generation, which we call the sustainable development. The third perspective is gender jurisprudence. So we can see that there is a famous case that was Delhi Democratic Working Women's Forum versus Union of India, as well as the Vishakha versus State of Rajasthan, where the court, the Vishakha versus Rajasthan, if you are aware, was the case of sexual harassment as workplace. Now we can see there is a legislation called the POSCO Act which governs this particular domain. But before that, Supreme Court has given a particular and a very uh, I can say a very detailed guidelines about such harassment in this case, and thus protecting gender jurisprudence and gender equality in our nation. Next, we can see in our next slide that talks about judicial activism and separation of power. So as I discussed both the concept of judicial activism, what it is, and what is separation of power. Separation of power and judicial activism, if we both see, then it is the question that therefore comes to our mind that in a plain understanding, yes, judicial activism is a threat to separation of power, because separation of power clearly says that there should be a demarcation between the powers of the government. The one should not overstep the power of any other organ or any other body. But there has been various instances where there was a mandate to overstep or to overreach particular field, and hence, if this judicial activism is used in a beneficial manner, is used in a way that is that is in correlation to the constitution, that is in relation to the democratic ideals, then it does not portrays a difficulty or does not portrays a threat to separation of power. There has been many critical analyses and criticism that saying that this leads to an unaccountable judiciary, because as judges are not elected officials, they are appointed officials, and hence they should not be bestowed with the power of forming legislation. This is just the part of the parliament. But we should understand that there has to be a balance struck between it. There has to be a balance between what the judges interpret and what they include in the legislation. There is no doubt that the parliament has the sole authority to form legislations. But if there is any threat to right and liberty, and I make you again remember what Montesquieu said, that separation of power is mandated for protecting the right and liberty of the people. If the right and liberty is not protected, then separation of power is of no use, is of no need. Hence, to protect the rights and liberties of people, if judicial activism is used, there is no problem in using that, or there is no problem in such particular mechanism. So as we now, so I open this question open ended, that is judicial activism a separation to power? Because I think by the end of this session you all will be well aware that how this particular mechanism, if used very crucially and judicially, is not a threat to separation of power. So now moving forward to our next slide, which talks about that the same question, that is judicial activism a blessing or a curse? Same. So what I enumerated before you, that if this has been used judicially, if there is a accountability, if the power of the balance of power is struck at the right angle and between the branches of the government, if there is a proper way of channel, and there is no such, there is no such laziness, there is no such inactivation in any part of the organ of the government, then there is no need of judicial activism. But if the other organs do not function in the way which is mandated, or if there is a social want, there is an urgent need in the society for any change, if that is nurtured, if that is answered by the judiciary through the mechanism of judicial activism, it is a blessing for a democratic society and not a curse. But at some instances where the judiciary, like there is also a term called over activism. So under that, when the judiciary tries to negate all the powers of the both organs of the government, that is, it is trying to curtail the powers of the parliament and executive beyond the limitation which is given in the constitution, then judicial activism could portray a threat. But till now in our nation there has been no such instances, because the judges are motivated towards social want as well as the cause of constitution. Next, in the next slide, we can see that there are some cases mentioned about judicial activism. The first case shown in Bharati, we just discussed about Maneka Gandhi also. Maneka Gandhi, we all know there's the case about personal liberty and how Article 10, the scope of Article 21 was expanded. So such expansion of Article 21 is, it leads to that the judiciary is not just interpreting the law, rather it is also adding its interpretation, or rather it's adding its explanation to the law for the betterment of the people. The third case which is mentioned is about Vishakha versus state of Rajasthan. This case which we talked about, that it formulated guidelines about sexual harassment in workplace. The next case is about National Legal Service Authority versus Union of India, very famous case, that is about in 2014, about the transgender community recognition of their rights. So you can see in this particular case also, the executive at that time or the legislature was not in a urgent requirement, or they were not bothering about the rights of this particular community, but the judiciary came in the role, came into this particular role of their judicial activism, and they granted some rights, and in furtherance of that, the other organs had also to accept them and to formulate legislations to recognize their rights. The last case which is mentioned here is about the Olga Telis versus Bombay Municipal Corporation. Many of you must be aware of this case. This particular case relates to the people who live on the pavements of the road. They were their house, where their houses or their what we can say, their unorganized structures were removed by the municipal corporation. They went to the Supreme Court and demanded for right to livelihood, but the municipal corporation negated that the land is of the government and you cannot live on it. But the court came in, the Supreme Court gave its order and the ruling that though the land is of the government, but the people who don't have any other access means to live, or they don't have any other structure to live of their own, they can utilize such place and they have the right to livelihood, which comes under the Article 21, or right to life. And thus it expanded the scope of Article 21. These are few landmark cases, and you can see there are all other various cases. There are various environment cases which also talks about judicial activism. Thus, our next slide talks about judicial activism in governance and policy. So we can see that in this, So this particular slide talks about that how judicial activism, how judiciary is always is included in public policy issues, that, and it is also directing the government the actions through its judgment. The Supreme Court interventions sometimes create interim guidelines that functions as de facto law. So there's two types of law, there is de jure law and de facto law. De jure law is whatever is mentioned in the constitution or any other legislation, a written form of law. De facto law, de facto law is that which is created by the court, it is created by the judiciary. So many a times it is, so many a times we can see that the court gives the direction to the government to frame policy in a certain matter. The courts give direction to the government or the legislature to frame a legislation, a law in a particular manner. And hence, we can see that judicial activism can also be used as a mechanism to frame policies, to frame legislations through the interpretations of the court. And next, if we can see, the our next topic is judicial restraint, the other side of the debate. So the other side, we can see there's mentions about judicial there's a so judicial restraint means that judicial activism is the overreach of the power of judiciary. On the other hand, judicial restraint is restraining the power of judiciary and limiting the power of judiciary just to the cause of interpreting the laws and just deciding the matter between parties. This, but if there is a need for judicial activism in our country or anywhere in the world where there is social want, judicial restraint always is a threat to the society, because if judiciary is curtailed and restrained, it cannot be given the free hand, or it cannot have the power to work in a matter which is in benefit of the constitution. As and there is a great talk also about judicial restraint. Judicial restraint in itself is a very big topic. For us in this discussion, we just need to know that opposite of judicial activism is judicial restraint, where the other organs tries to restrain the concept of the powers of judiciary. Hence, moving forward, and to the because of restraint of time in our session, we come to the conclusion. The conclusion, just we can see that in concluding part, or rather me to conclude this talk, we all should have came to such a parlance or such understanding that is there any is in India right now, what the stance of the Supreme Court has been, or what the stance of various high court been, is that uh, overreach of their power which is threatening the democratic ideals? Is the acts of judicial activism which has been performed in various cases by the courts, does that result to shake the foundations of democracy? So in concluding, we just need to understand that till the extent any organ of the government is functioning as per the constitution, respecting the constitution and the democratic ideals for the benefit of the society and social justice, till at that time no powers of that particular organ should be curtailed. But when such organ or when such particular institution tries to overreach it and tries to obtain the sovereign power above the constitution, it should be curtailed, it should be restrained. And respecting the time limit, I should open the floor for questions. I can see there are some questions in has already been flooded, and if you all have any questions regarding this topic, regarding any other topic revolving around this particular issue, you can put forward in the Q&A box. And if many of you, if you are not aware that how to operate this Q&A option, you can see on the right hand bottom corner there is a logo made, like there's a circle, square, triangle option. If you click there, there is a option of Q&A. You can go there and you can post your questions. I can see there are some questions. So the first question is, sir, what's your opinion on the appointment of judges based on the collegium system? Is it not an overreach of Parliament on the functions of judiciary? Should the collegium system be stopped and a new impartial method be taken? So, first, we should understand that I guess some of you are raising hands, and what have been informed to me by the host that you cannot unmute yourself and ask the question. So, if you want, you can post the questions in the particular chat box. So, then your question could be answered. So, if you're talking about the collegium system, first of all, we need to understand that collegium system is where the senior most judges, along with the Chief Justice of the Supreme Court, decide upon the appointment transfer of judges. This is the collegium system, that judiciary adopting the role of administration for its own appointment and transfer. What the parallel mechanism which was brought by the present government was that there would be a committee formed which would consist the prime minister, the law minister, the chief justice, along with the leader of opposition, and they will decide upon the matter that which judge to be appointed and which one to be transferred. But this particular legislation was struck down by the Supreme Court. They wanted to retain their own collegium system. So the collegium system has their own benefits and their own demerits. If we see that because the one reasoning which was given by the court was that in the collegium system, when the panel of judges, when they are deciding upon the matter of appointment or transfer of a judge, they look into other various matters, other there are various personal matters also about the person in question when the collegium is deciding, and hence it is a closed door discussion. The discussion or the papers of a collegium are not made public or are not circulated in the public domain, because there are many informations in that confidential file which is about the personal detail of a person. Because when you are appointing a person as a judge, it is a very big task and a very big role. Hence, this is could be a benefit for retaining the collegium system. But on the other hand, when we talk about the system which was brought by the present government of appointing judges, this is a more, you can say, a more impartial form, a very transparent form, which can be reasoned on the basis of a democratic society needs a particular system where judges are appointed through a mechanism where all others also have a say. But what I consider is that the collegium system should be retained, because the court, till now in India, the court, the apex court, has retained that position, that stature, that it has not interfered or has not given any biasness towards any person in appointing a person as a judge. So I consider that this has answered your question. The next question, if I can see, is that the adoption of PIL doctrine by the judiciary, and after, do you believe the judicial activism as idea has been warning for the regular uh, talking about the PIL, as I mentioned, you can see that there are many legislations were brought into India because of PIL. There was cases about the under trials. There was case about the rivers. There were other environmental issues which Mr. MC Mehta always tried to take up. Because of PIL only, many international treaties have been recognized by our nations, and legislations have been made in respect of that. And hence, if I can see that PIL has served as a mechanism for the poor people of our nation, for those sector of society who are yet not been touched by the sunlight of judicial process, who have not yet been encouraged so much, who have not been legally aware to demand their own right. So PIL is not a one waning situation for the democratic or the legal discourse. Rather, in my opinion, judicial activism is that idea, and through PIL, it has strengthened the legal discourse. And then there's one more question which again. And then, well, when I what I intend to ask is whether ever since the introduction of PL there has been no significant measure of judicial activism that has kept at pace with the evolutionary aspect. So through after the introduction of PIL, if you have seen that, if you say that there is no after the PIL also, if you see, I mentioned about the 2014 case of gender jurisprudence, where the transgenders have been given the right, or the transgenders have been bestowed with some rights by the judiciary. This is also a very good example of judicial activism. And so not just the PIL was a very recent judicial activism case. There are many other cases after that. The recent 2024 judgment. Then before that, there was a judgment which was relating to the cleanliness of rivers in the state of Himachal Pradesh and Uttarakhand. And then there's also, we can see that in this there's a question about collegium also, this collegium case also, that the court striking down the legislation and retailing or curtailing its own measures. Such other cases also is also in the normal paradigms also, if we see the any other day, you can see the judgments of the Supreme Court, there is some hint about judicial activism. It is not just the Supreme Court comes up and abruptly forms any law. There can be a very small form of judicial activism also seen in that. There is another question that in what ways can the judiciary balance its duty to deliver justice with the need to respect the boundaries set by the constitution. The judiciary does not transform into, so how to set the boundaries and the balance how is struck. Therefore the whole system of judiciary has been made from the lower court to the higher court to the different benches, and hence through through the appointment process through which they reach that position, through the different jurisprudence which is made, there is such a domain created that till now there has not been such overreach. And what I believe, that because of such a elaborated judicial institution in our country, if a particular bench of the Supreme Court also delivers any judgment in overreaching this step, then it could be struck down by a larger bench of the court. So there is such act mechanism present, so which can curtail the overreaching or overstepping of the boundaries. What is the procedure if the judiciary overstep beyond what it is supposed to by using judicial activism as a reason? That is, can any institution call out the judiciary if it goes beyond? Yes, so we can see that there are many instances where the court has struck down the laws of the government, but then also at last the parliament can amend the constitution through various other ways, and it can also curtail the power of the judiciary. But that instances are also because there is a mutual understanding between the organs of the government, and no other organ tries to overreach its power, because the other two will try to curtail it. Hence, when if judiciary also oversteps or over does any particular activities, the parliament comes into the consideration, and the parliament tries to restrict that particular act. Because there is a collective decision of the judges, there is very less chances that such step has to be taken. And if such step is taken, or if any particular judge because of his personal motive also does so, there is a process of impeachment which the parliament can undertake. And hence the checks and balance system which is given by the constitution till now works in such a smooth manner that it does not put question upon how the overreach could be stopped. Then there is other question that The question is that yeah, so the question is, what authority sets the standard on the basis of which judiciary can challenge the separation of power? What the so what rather than authority set any authority, any institutions setting the standards, we have the concept of jurisprudence. We have that what are the precedents, what are the legal documentaries. These are the authorities, or these are the understandings on which a court decides that what is the limit, or and also the court analysis does an analysis of the social understanding of the society, that yes, according to what the society needs, according to what the jurisprudence has been, what the precedents has been, these all are the authorities which sets the standard of what a separation of power should be, and how it to what extent it can be challenged. Then there's a question: does the government have the power to select judge and change the criteria if it's already written in constitution? If constitution amends the criteria, can judges and lawyers challenge this amendment? Yes. So this question about challenge the amendment of appointing of judges, the same happened in India when this current government brought a new system of appointment of judges, and thus it was challenged and it was struck down by the Supreme Court. So I guess that if you go and read upon that judgment, your question could be better answered there. Then there's the one more question which talks about uh, Nada Pathan. I guess I am not aware of this word. What you have mentioned. So, temple is not a place for cutting birthday cake. Kerala High Court prohibits videography by vloggers in Guruvayur temple premises. Is this case showcasing judicial activism or judicial overreach? So you see that this particular case, if I am understanding in the right way, the court has curtailed vloggers from videographing or using the temple premises for particular vlogging of videos, or for making videos of their birthday celebration, if I'm not right. And the court is restricting this. Has if you remember that there in the two theories of judicial activism, the one is about social want. Social want is for the benefit of the society. So the court also read the particular jurisprudence. The court saw its precedents, and the court also gave its consideration upon the religious texts and also the societal arrangement, that how the conduct of a temple should be, how a temple has to be regulated, and hence by curtailing such activities in a particular area, in a particular temple premises, this will benefit the society rather than curtailing the rights of the people who are making videos and photographs there. So I consider that this could have answered your questions. And with this, I guess if there are no further questions, and because there are other questions too, but they are similar to the ones which have been asked or which have been answered. Kindly mention the PLD, I guess. If you could clarify about what you are asking. If you are, if I guess, if you can clarify what you are asking, Mr. Amara Abiye, that kindly mention the PLD. So I guess you are. Asking about the collegium case, which you can refer to. So there are the various collegium cases. There you can, if you go, now if there's a NJA. The recent judgment is about the NJAC, the collegium system, and if you go about the NJAC case, you can see that you can read upon there. And there are also different various previous cases. The first collegium, the second collegium case, you can go and check upon that too. And hence, I guess there are no further questions. I would rather forward the floor to Madam Preeti, who can take forward from here.
Thank you, Mr. Anand, for such an enlightening and thought provoking session. We appreciate your time and effort in sharing your knowledge with us today. Finally, I would like to express my gratitude to Mr. Ayush Gaurav, our guest speaker, Mr. Anish Anand, and all of you, the participants, for joining us. Your active engagement and enthusiasm make this platform thrive. That's all for today's webinar. We look forward to welcoming you again at our next event. Have a wonderful evening.
So thank you so much to the team of Law Jurist and Mr. Ayush Gaurav, Ms. Preeti, and the other media team who has facilitated this particular session. And I truly believe, and I thank you all for attending this, and I truly believe that this will definitely leave an impact on your thinking. And whenever in the future, if there is a discussion about this topic, you all will be prepared answering all the questions. Hence, again, I put my gratitude towards the team of Law Jurist. Also, to mention that this company, which has started such initiatives on a pro bono basis, they do not charge for such particular sessions, and they also have various other activities which they are doing on a pro bono basis, which is very beneficial for our society, for the legal fraternity. I wish them all the best to all of you. Thank you. Thanks a lot.
Thank you so much, sir. Now you may leave.